A federal judge has ordered Texas to temporarily suspend enforcement of its new abortion law. The judge's decision stems from a lawsuit filed by the Justice Department against Texas, calling the ban unconstitutional. The law prohibits abortions around the 6-week mark before many people even know that they're pregnant. CBS News correspondent Mireya Villarreal is in Fort Worth, Texas, with more.
Abortion rights advocates are calling this ruling a win for women in Texas and a strong defense of Roe v. Wade by the Biden administration.
This is the justice we have been seeking for weeks.
The U.S. Department of Justice sued Texas and its governor to stop the law from being enforced. Last night, Judge Robert Pittman sided with the federal government and granted a temporary restraining order. During a special session last month, Texas legislators passed a law that bans abortions once cardiac activity is detected, usually around 6 weeks before many women know they're pregnant. It also bans abortions in cases of rape or incest. The law is enforced by allowing private citizens to file a lawsuit against anyone who provides an abortion or assists a woman in getting one.
This law took effect September 1st, and since that time, there's 130 little babies every day that aren't being aborted in Texas. So that's one tangible effect, already over 4,000 as we speak today.
Since the law was passed, abortions in Texas have largely stopped, and some women are now traveling to other states to get the procedure.
Last night, we reached out to some of the patients that we had on a waiting list to come in to have abortions today.
But other providers are fearful, waiting for a definite ruling.
It delays people access to safe abortion and displaces them, requires them to travel or delay the care that they need.
The state of Texas has already filed its notice to appeal with one of the most conservative courts in the country. Meanwhile, not all clinics here in Texas have resumed abortions after 6 weeks because they are fearful they could be retroactively sued. Lana?
Mireya, thank you. For more on this, I want to bring in Harry Litman. He is a former U.S. attorney and host of the Talking Feds podcast. Hey there. So what are some of the factors that played into the judge's ruling on this?
Well, basically, the judge, in a very methodical, very meticulous ruling, marched through the factors for not just who wins, but can you actually freeze the law? And he found things like the balance of equities favors the United States and the women who are right now suspended from having an abortion. The United States is likely to win the suit, and therefore it makes sense, pending his final decision, to actually keep the law from going into operation, that they have standing and the like. But the big things, Lana, is he finds they're likely to win, and the equities are really in favor of stopping things. Now, what happens is these are two separate rulings. The idea of the stay can now be appealed directly to the Fifth Circuit, the Court of Appeals, between the district court and the Supreme Court, and they can just rule on the stay and say, we don't agree that the U.S. is likely to win. We don't agree the balance of equities. We're going to dissolve the stay. Everyone is now holding her breath in Texas to see if that's going to happen.
And we understand that the Office of the Texas Attorney General says that it's already taken steps to appeal in the Fifth Circuit. So, Harry, how long do you expect that this temporary block will actually hold?
Yeah, so they've taken steps. They've not only taken steps, but they've tried hard to get a panel, the same one from before, that's likely to dissolve it. Basically, it either will be dissolved quickly, like in a week or so, or it'll hold for a long time. Because if the Fifth Circuit doesn't dissolve it, then the district court has to complete its review. This was just a preliminary decision to keep the law from going into effect while the review was made. Then it would go to the Court of Appeals, which would do its review. Then and only then could it go to the Supreme Court, which already would have decided probably the case from Mississippi. So basically, it either is going to be dissolved in quick order or it will hold until, into next spring.
So, Harry, I do want to ask you more about the Supreme Court's potential role in all of this. But even before we get to that, Part of what's really unique about the Texas law is the provision that allows private citizens to file civil suits against anyone who not only performs a procedure but assists in any way after that 6-week period. Are physicians who resume the procedure while enforcement is paused protected then from legal action?
Probably. It could be possible for them to say after the fact, if things were dissolved, you guessed wrong, but it's very unlikely. And that enforcement scheme, by the way, Lana, was a big part. It's the other factor I should have mentioned in the district court's decision. It was the actual enforcement scheme, and as the court found, the purposeful attempt to keep people from enforcing their rights that also motivated the decision to enjoin the statute. That figured in, and that's a very unusual, unprecedented really, is the word the Chief Justice of the United States used about that scheme. So technically, yes, practically, no. Abortions can resume, I would say, with relative impunity, even if the law is designed to try to go back after the fact. I don't think that effort would succeed.
But providers may still find themselves needing to defend themselves against those types of lawsuits. So
that's true. They might have to
promised,
defend.
I did want to get back to the Supreme Court because, as you're well aware, Harry, in a 5-4 ruling last month, the Supreme Court declined to stop the law from going into effect. They didn't, however, rule on its constitutionality. What do you think the chances are that the Justice Department's lawsuit against Texas is eventually decided by the High Court?
Well, I think it will depend on what the High Court does with this other case, Lana, from Mississippi. So if it decides that case, they already have accepted a case from another state with a slightly less severe statute that says after 15 months it's no good. They will hear that in December, decide it by June. If they make a decision, say, overruling Roe, or they otherwise change the law, I think what they'll likely say after the Fifth Circuit, either party who loses will appeal to the Supreme Court. The Supreme Court will likely say, hey, guys, we just decided this Mississippi case. We're going to remand it back all the way down to the district court to think about the case in light of what we've just held in the Mississippi case. So that's a sort of decision in that sense. They would accept it, but accept it and then bounce it back down to apply the law that under this scenario they would just recently have framed.
And Harry, in the Mississippi case, do you think that it is a possibility that the Supreme Court decides to overturn effectively Roe versus Wade?
It's more than a possibility. It's like a freight train coming at them. There are many reasons that you wouldn't have thought they would have done that, but the fact that they took this case and the fact that the Mississippi statute simply can't be reconciled with Roe versus Wade and the Casey case, and they are now going to have to decide it, to me, it's very, very hard to figure out what they do other than either effectively or actually overruling Roe and Casey.
Big stakes.
It's a very real
Harry
prospect.
Litman.
Thanks, Lana.
Thank you.